All right, everyone. It's so nice to see everyone. I hope you had a good lunch. So I'm very excited about this last panel. I'm Olatunde Johnson. I'm on the faculty here at the law school. So when we opened today, Zanel called on us to at least consider what it might mean to reclaim the Constitution as a location to make progressive arguments about distribution and equality. And over the course of the day, we've really pressed at that notion, right? In what sense is this even a reclaiming? Can we use that language? And should we reclaim? We've heard about the limits of the US Constitution specifically and of constitutionalism generally. We've touched on the question of whether there are trade-offs involved here between engaging in constitutionalism, whether it's directed at courts or at legislatures or just a way of energizing social movements, and engaging in a different kind of politics outside of constitutionalism. And we also got different visions of what progressives are currently doing. Even in the last panel, some said we already make too many arguments focused on courts and constitutionalism. Others said that we need to make more of those arguments. And then also in the last panel, I think it was Ash, who said, at the end of the day, these aren't our questions to answer as law professors, that part of what we need is to see how people in social movements and in politics are answering these questions. So we have a really varied panel here to help us think through these questions, and they all have multiple identities. Don't put them in a box. They've worked in and out of politics. They've been engaged with social movements. They've written articles and books on these questions. And we're going to do this in a little bit of a different format. I think what I'll do is I'm going to put a general opening question to them, and then before each person speaks, I'll just say a little bit about who they are so you can get a sense of where they're coming from on these questions. So the general question that we were going to grapple with just as an opening is to think about, in the context in which each individual operates or has operated, what they see as the role of constitutional arguments on behalf of a broader and more inclusive distribution of wealth, economic power, racial justice, whatever domain, and gender inequities that they're operating in. And it would be useful in that vein to talk a bit about how you engage these questions in your work now, and also what, given the conversation that we've been having today, you envision as possibilities, but we may not get to all of that in the opening round. And I think another thing to really put on the table is, when you're making constitutional arguments, to whom are you making them? There are sometimes we envision that these arguments are made primarily to federal courts. There's obviously state courts, but there's Congress, the executive branch. There's citizens and communities. Many of us engage in constitutional argumentation as a way of mobilizing and drawing on long political traditions. I always begin my statutory class with Martin Luther King talking in the I Have a Dream speech. He wants a Civil Rights Act of 1964, but he's appealing to a constitutional tradition, and one that's never been realized and is kind of imagined. But I think it's discursive, it's rhetorical, and it serves a kind of grounding function in ways that people have talked about. So to kick us off, we have on these questions, we have first ReNika Moore, who is the director of the ACLU's Racial Justice Project. She's worked in a variety of domains, including at the New York AGs. She was head of the Department of Labor, and she headed up the NAACP Legal Defense Fund's Economic Justice Program. And so just starting with you, would love to hear about your work, how in your current capacity you engage these questions.
Sure. So can everyone hear me? So I think, how we see constitutional arguments in a lot of our work is that it is one tool, often not the most used tool in our toolbox of advocacy, for reasons that are probably apparent to this audience, in the sense that we have a very hostile court at this moment, and interpretations of the Constitution and its protections have been fairly limited from a racial justice standpoint. And so what we have been able to achieve some success in a couple of areas that I'll talk about a few cases that we've been able to achieve some success. But what we have done, and even in my career as a racial justice advocate, I think have much more relied on statutory arguments. We have relied on influence in terms of in the regulatory space and in some other areas of sources of rulemaking and obligation and remedy. When we think about it, even something that I've noticed in the context of the ACLU, which very much as an organization believes in the power of the Constitution. As Olatunde reminded me, one of our tags used to be the Bill of Rights is our client, and so I didn't hear all of his comments earlier, but as Professor Rana emphasized, the kind of veneration of the Constitution is very much kind of in the DNA of the organization. We still do see the limitations of that in the racial justice space, and we see it, even in terms of who's understood to be a constitutional lawyer who is making arguments about the Constitution in our Supreme Court. In our case, it's a pretty exclusive environment. So we see that when we think about the lawyers who are dealing with some of the most egregious violations of our Constitution in the criminal justice space, in the against workers in the wage and hour space, kind of legal services workers and other kind of workers who are dealing with communities that we see as most vulnerable. Often those lawyers are not necessarily making or even always fully familiar with constitutional protections and arguments. So it can feel a bit removed and attenuated from where the rubber meets the road of the problems that we are most concerned with. That being said, there are some basic tenets of the Constitution that I think are very valuable and are deeply held by the communities that we work with and are very much understood. And so we see that in our relationship to our communities and to the folks that we represent. And so that is often a dialogue and understanding like what values they hold dear, what goals they are trying to achieve, and how the law plays into that and what we think we can argue. So we do keep it in a conversation as opposed to us holding the information. And so I really like the comments earlier about not allowing the courts to dictate what the Constitution means. And it occurs to me that I need to say that more, because there is sometimes some deference in terms of who gets to say what our constitutional rights are. And so recognizing that can be defined in much more broadly, and has been in our country's history. I think in terms of the specific claims that we have made just in this term alone, we've seen just a recasting of the Constitution, which is typically been a fairly conservative in terms of the rights of minorities, little n, but including people of color. When we think about the arguments in the affirmative action cases and just a recasting of the history of the 14th Amendment, we think about even how the record is dealt with and how the stories are told. So we have serious concerns about this moment and how our Constitution is being interpreted, and wanting to be sure that we are in the room and able to push back on those narratives and talking about it. And for my team, the cases that we've seen this term are the affirmative action cases, the voting rights cases, and also we've seen cases that involve kind of the story of the Constitution. The case Brackeen v. Holland is the Indian Child Welfare Act, and my team also handles Indigenous justice work. And so when we think about the rights of Native Americans and the rights of property and the history of that becomes extremely complicated. And there's just a reality that the Constitution assumes that is not held by many of our clients and the tribes that we represent. And so thinking about the Constitution, there are places and spaces that it doesn't reach by its premise. And then in terms of the Constitution, the amendments that even by their own terms don't reach. So we often are working on behalf of people in prison, people who are in state custody, and their rights often, the Constitution is not recognized in the same way. And similarly for the students that we represent in many of our school discipline, school policing cases, how the Constitution applies in our schools looks very different, and what students' rights are against detention, against restraint, and we've filed amicus briefs in the last couple of years about what those rights look like. So we are mindful of like how we're arguing the Constitution and how we're thinking about how those rights extend, when they don't extend, when they should extend, and but yet haven't been recognized. But we see real constraints on how far we can go and how much we can attain for the communities that we are working on behalf of when we start from a place of constitutional law. So I'll stop there.
Yeah, and we can pick up on some of those. I mean, some of what I'm hearing is that most of the work is in the statutory space. And I think one question that from the civil rights perspective to really think about is whether we were kind of shunted into that space. I remember that cases like Milliken and San Antonio versus Rodriguez, you look at all those cases and you realize, well, part of it is that we are constrained from being in the more capacious notion of the Equal Protection Clause. And so our only hope is in statutes. But another way of seeing it is that the statutes are where we're going to have our full flourishing and realization of whatever vision of equality that we're trying to instantiate. The other thing, just since both of us got our start at the NAACP Legal Defense Fund, I think most of the constitutional cases outside of the criminal justice context were defensive. I mean, other than the Section 5 of cases. I mean, so we're on the defensive side. When people are claiming Constitution, it's usually defeats some sort of racial remedy. And one of the things that the ACLU did in Fisher that was very different, which is one of the affirmative action cases, was to tell the whole history in an affirmative way of the 14th Amendment. And that hadn't been done in the prior cases. There was a more kind of defensive reading of the 14th Amendment. And I think now in the Harvard UNC cases, yes, and in the Fisher case, ACLU has been the one charged with putting out the record on a more affirmative vision of the 14th Amendment. So that's kind of a shift. I think it's a way you can use some of the defensive cases more affirmatively. All right, so next we're going to go to Alex Hertel-Fernandez, who is a professor here at the School of International and Public Affairs, but for the moment is at the Office of Information and Regulatory Affairs at OMB. And before that was the Deputy Assistant Secretary for Research and, what was a long title?
Evaluation.
Research and Evaluation at the Department of Labor. So there are a range of things that you could talk about with us. I mean, first of all, how these constitutional arguments are manifest in the executive branch, certainly about the labor movement, but I think you were going to start with American political development. I mean, you've written a lot about the role, how conservatives and big business and the right are able to exploit federalism arguments and the anti-democratic features of our Constitution, and the ways in which law and courts act as various veto points to more progressive social change. So let's start there.
Sure, happy to, and thanks to the organizers for putting on this really fantastic conversation. I'm really happy to be here, particularly because I'm an interloper, at least on two levels. The first is I am not a lawyer, so disclaimer up front, I'm a political scientist, and I'm also away from academia right now, serving in government, although I'm speaking in my personal capacity, and my comments don't reflect the positions of the Office of Management and Budget or the administration. But with that in mind, I want to share a little bit about what I've been up to together with collaborators in political science in trying to create a field of American political economy, as we're calling it, a closer attention to the mutual constitution of markets and government in the United States, paying close attention to the design of institutions here in this country and how they compare to other countries. And I think there are some nice points of intersection between this project and the project of constitutional political economy that Willie and Joey have laid out and that we've heard in our discussion today, and also some places I think where there's some differences that would be helpful to spell out. So I mentioned that we take a comparative approach, and very much in the spirit of denaturalizing what we take as given, what we do not question about our institutions. I think a comparative approach also helps us see some of these places where taken for granted sets of rules and institutions deeply shape the possibilities for policy and politics in the United States. And in our project, we really focus on three aspects of the American state that we think are critically distinctive in comparative context with other rich democracies. And looking through these lenses, we think can do a lot to explain both where we see opportunities for political change and where it might be stymied, particularly as we think about opportunities for more egalitarian racial, social, and economic outcomes. So these three features of the American state that we focus on in our work and we foreground are first, a fragmented and territorialized state with fragmentation of political power and authority across people, places, jurisdictions, and organizations, deep racial and ethnic cleavages that are reflected both in the mass public, but also crucially reinforced through feedback loops with our political institutions. Last, fragmentation of our economic organizations, particularly thinking about producer groups like business and labor. All of these flow from the structure of the American state, including the Constitution, but also other features of our politics and economics. For the sake of time, I just want to walk through the first, which I think is the most crucial for some of the conversations that we've had today, and talk a little bit about this fragmentation of the American state and how it can limit and constrain some of the opportunities that I think we all on this panel would like to see. So the way we see it, there's fragmentation of authority and power, both horizontally and vertically. And together, this encourages gridlock, particularly at the national level, and also offers an unusual array of venues for political coalitions to pursue policy change, particularly as compared to other countries where there might just be one national venue for change. In the US, we have many opportunities. And so horizontally, we see fragmentation across the different branches of government. Vertically, we have substantial delegation of governing authority to the states and localities. And I'll talk about more in a moment how that really is distinctive compared to even other federal countries that have states and localities as well. But together, this fragmentation adds up to a record number of veto points. I think David on the previous panel mentioned that we are number one when it comes to the number of veto points across other countries. That plainly has effects on our policymaking process by constraining large national change. It also means that defending the status quo is a lot easier than it is in other countries, and therefore power imbalances that are reflected in the status quo are more likely to endure in the US other than compared to other countries. Relatedly, we have, compared to other countries, a relatively weak and fragmented bureaucracy, particularly at the national level. Regulatory power is split across a number of different agencies with a large role, as this audience knows, for the courts in overseeing activity, increasingly so that regulatory agencies want to do. Equally important, we have a record number of political appointees as opposed to career civil servants in these agencies as compared to other countries, whereas in other countries there might be dozens or hundreds of appointees. In the US, we have thousands, which has implications for the kind of policy change and nimbleness of bureaucracy. A second distinctive feature that we highlight is the unusual role of the courts, which obviously is front of mind for us now, but is has been the case historically and also sets us apart comparatively. The political theorist Samuel Huntington described us as a pre-modern Tudor state in this respect, that other peer democracies have separated the legislative and judicial powers as they were modernizing, but those two remained fused in the courts in the United States. And so the courts have this outsized control that just does not exist in other countries. And then last, there is this high degree of decentralization embedded in the Constitution and our related political institutions. As I was mentioning before, we're hardly the only federal system, but other federal governments either delegate more limited power to subnational governments, states, localities, or they have more leveling mechanisms between states and localities, including revenue sharing or interstate fiscal arrangements than other countries, something that I know folks in this audience have also written about, and important ways that constrains the kinds of possibilities for redistribution and more egalitarian policies at the subnational level, picking up on a theme that I know we were talking about earlier today. It also denationalizes some important aspects of our political debate, especially over some key policy levers that we know matter for pursuing more egalitarian racial outcomes, like education, criminal justice, and housing. So together, we think these aspects of the American state add up to constraining the kinds of possibilities for more outcomes, and they enable moving resources across venues in ways that tend to favor more well-organized actors like businesses or those that have the political savvy to be able to relocate their battles from the courts to the states to the cities on a way that can add up and ladder up to national change. And also together making it easier to defend the status quo rather than bold new national outcomes. So on that, I just wanted to pause and turn it over to the rest of the panelists, but I hope that we can come back to some of the ways that these distinctive features of the American state both constrain and enable the kinds of opportunities that I know we all are hoping to explore here.
Well, the fact that you ended it like a political scientist, it constrains and enables. And there's part of me that was tempted to ask the bottom line: does it constrain more or does it enable more? Because I think one of the questions is whether these features make our journey that we've been going on today kind of a fool's errand, right? That there's certain structural features of the Constitution that unless we change them, which is something we do want to talk about in the context of this panel, then we are making a necessarily limited set of arguments. And that's taking into mind if we want to invest in constitutionalism at all, which is on the table. Some people don't. So I was going to turn next to Katherine Franke, who is a professor of law here at the law school, does a lot of things, including directs our Center on Gender Justice. And you can talk about anything you want, because you were going to talk about reparations, but maybe you were going to talk about the ERA, and I don't know what strand you want to pick up next.
Thank you. Yeah, this is really fun. And I just want to say I've really, really enjoyed this conference and the panels. I've learned so much, and just want to thank the two of you for giving us a device that brings us together to have these interesting conversations. So I teach, just to go back, we're going to keep referencing by distinction Ash's comment. I teach and I write as a scholar, but my heart is really as an activist and a political organizer these days. And so I run two projects here at the law school. One is on religious liberty, and how do we rethink religious liberty claims at a point where they're being used as tools to gut other fundamental rights, but also to privilege the rights of right-wing Christian evangelicals. And then also the Equal Rights Amendment Project, where we're working to get the ERA over the line as the 28th Amendment, and give it some real meaning, rather than just finishing the job once we get it fully ratified. And I think these two parts of my work serve as very interesting counterpoints for so much of what we've talked about today. So many of you, I think, have said in real material relief, and so smartly, that we're living at a time of widespread deconstitutionalization of a progressive political economy agenda through a kind of neo-Lochnerizing, which has been, we all know, the long game for the right for a long time. And I think if there's anything that we need to get better at on the left is to have a robust long game where we dream and things that were unthinkable or ludicrous become our reality. We're too pragmatic, I think, on the left. But this game of theirs, of this deconstitutionalization of the left political and economic agenda, I think has resulted in the evolution of a robust constitutional right of withdrawal. Withdrawal from the social compact, as the court in Jacobson recognized it in 1905, and the withdrawal from what they have, I think, in many regards, successfully portrayed as an incompetent state. And so this right of withdrawal has produced a kind of absence of public morality, of public values that underwrote a positive and affirmative political economic vision for the country. And so recent cases that I think are an excellent example of this, of course, are Bruin, the gun control case where the armed citizen stands up against an incompetent state that can't keep them safe. And so each of us must bear arms to protect ourselves. Same with COVID, with the COVID cases. The state had very weak capacity to stand up for the public's health in the face of objectors who, for a range of reasons, including religious, but not only, reasons, objected to the state intervening in ways that in a non-pandemic time might be less compelling. And the religious liberty cases are an enormous example, I think, of the ways in which the Constitution is being deployed for the purposes of exit, for the purposes of an evacuation from the state and public values, collective values that we would count as values that are part of a prior era's social compact or political economic agenda. And at the same time, I think this period of evacuation or absence or withdrawal has made space for a kind of presence of certain kinds of rights-bearing subjects. And there I specifically would reference the LGBT community. Like, we've been looked to as the paragon of the modern civil rights movement, having won Obergefell in same-sex marriage rights. But that right itself represents the privatization of sex, desire, love, family, responsibility. The privatization of sex and sexuality, not as a constitutional presence or as a weak constitutional presence. I think that if not finishing the job of this deconstitutionalization of other fundamental rights, in some ways reinforces it. So we celebrate this privatized, loving subject, maybe as a matter of interest convergence. It may be in the interest of some to recognize the marriage rights of same-sex couples because marriage is so wonderful. And in so many respects, the gay rights movement turned into a marriage rights movement in order to be successful. But I think it's also more the fruits of a neoliberal gay rights movement that we see in Obergefell that fully and affirmatively abandoned any kind of commitment to a redistributive politics in favor of a thin, and I think unfortunately short-lived politics of recognition in the privatized space of the home and the family and the bedroom. I could weave in reparations, but I think I won't. It's another thing I could talk about. But I guess the last thing I'll say is about the ERA for right now. And the fun stuff about the ERA is to rethink a different way, or to use the ERA as a moment to rethink the Constitution and the Constitution's approach to equality, not by merely re-ratifying or explicitly ratifying the protections that are there implicitly in the Equal Protection Clause of the 14th Amendment for women or for gender more generally, but to have an entirely new source of equality rights apart from the Equal Protection Clause, and I would say from the First Amendment, because what the court has done in the religious liberty cases in this last two terms is find a new source for equality rights only for certain religious dissenters that far exceeds what race-based equality is afforded under the Equal Protection Clause. So the 28th Amendment could give us the opportunity, and I think does right now, gives us the opportunity to talk about a new way to recharge, supercharge, what was the term you guys were using on the last, supernovaing, an idea of equality that modernizes it with a substantive version of equality, not just a formal version of equality. And I tore my hair, well, little hair that I have, I was so frustrated last Tuesday when there was a hearing before the Senate Judiciary Committee on the ERA. And a couple of the Democratic senators threw softballs to the people on the panel who are on our side, saying, won't the ERA bring strict scrutiny for sex-based cases? And they're all like, yes, yes, won't that be great? And you know, all the work that we do is about saying, don't sell so short. Strict scrutiny has been horrible in the race area. Why would we want that too? So ask for more and use the ERA as the opportunity to both indict equal protection in the 19th century version of it that we have in the 14th Amendment, and update and modernize not just equality for women as compared with men under the 28th Amendment, also update, I think, generally and pay back the race-based movements for justice and equality by lifting up what equality means under the 14th Amendment too.
Hey, well, first of all, thanks for reminding us that denaturalizing and supernova were some of our words of the day that have been repeated through the panels. I was a little bit skeptical. I went to the ERA conference that you had last year, and I was a little bit skeptical of the ERA movement, of what we would gain from having state level and federal level ERAs at this time. And I was really persuaded by the overall effort, in large part because of a story that was told about Virginia. And I hope we can come back to about the way in which the ratification debates that took place not too long ago in Virginia around the ERA had a much more expansive notion of what gender equity was. And so as we're thinking about state constitutionalism and also about arguments, you don't have to speak to that if you don't want to, if you're going to panic, Zephyr. We have Zephyr Teachout, who's a professor of law at Fordham Law School, although she's right now at the AG's office and has previously run for governor in our state, and has engaged politics, obviously at the state level on these questions. So you write about lots of different things: anti-monopoly, corruption, technology, and democracy. And so those are some of the core areas we began the day with in thinking about how constitutional arguments could be deployed. So we're looking forward to your take on this question.
Thank you, and thank you for a truly extraordinary event today. I have felt myself tipping from side to side as each person speaks. Very difficult and critical questions. I am currently working at the Attorney General of New York's office, and I speak here as myself. Nothing I say represents the views of that office. So I'm going to take the perspective. I'm going to answer the question of not how going forward, but how in the past I have used or not used constitutional arguments in areas involving economic power. So I really appreciated Dave's taxonomy earlier. The first category is for the first part of my career, I was engaged in a very traditional structural argument about the nature of the anti-corruption principle in the Constitution, argue that there is such a principle, that principle has real legal power, should change our decisions in cases like Citizens United, actually preceded Citizens United, and was tragically cited in the dissent. But it was a sort of classic high stakes argument within the constitutional tradition that had the effect, and I think part of what we're talking about now, of I think a serious argument, but also of then sanctifying that constitutional tradition. And I think one of the questions we're dealing with throughout is, to what degree does our re-sanctification bring some genuine risk? And to what degree is it absolutely necessary, because these are the tools we have? The second area related to economic justice that I have been the most involved in began when my dear friend Jed introduced me to Barry Lynn 11 years ago. And I, because of my interest in anti-monopoly work and not knowing where to turn, became part of what at the time was a relatively small community, and it has grown, that had a 25-year anti-monopoly programmatic approach. That doesn't mean everything has followed in lockstep or anywhere near the particular plans, but it was an understanding that there was a long-term goal of changing the way that American policy approached concentrations of power. Part of that was recognizing, denaturalizing concentrations of power, invigorating congressional and state house energy. And it involved a whole series of strategies, a very plural approach. But when I think about the degree to which it was and has been constitutionalized, the answer is a little, but not a lot. And I would point you to the public statements recently. I'm sure Will and Joey were happy to see Cantor yet again citing your book yesterday. But if you look at the recent statements of Jonathan Cantor, who has been part of this anti-monopoly community for some time, Lena Khan, who I met before she went to law school, and others, there's a lot of discussion of democracy, a lot of infusion and active work to reframe and re-see concentrations of power and the domination and the effect on the human spirit in terms of human freedom and in terms of democracy, with faint echoes of the First Amendment, faint echoes of some structural elements of the Constitution. But with few exceptions, and to your question, to relatively few audiences, the constitutional argument per se has not been central. So Barry's most recent book, Liberty from All Masters, does explicitly engage the constitutional history in question. My most recent book does it, but only in very small ways. And far more often, it is used as one of a series of potentially rich symbols and historical moments and stories that can be called upon. The Reconstruction Amendments clearly playing a very central role, but not separate from other kinds of historical moments, but rather as an array. I was talking to Dave, this biblical interpretation, this is one of the books. It's not the only book that one can go on for, and so a lot of democracy talk, relatively little constitutional talk. Now the constitutional talk that has been there, and you'll see this in Kahn's writing, speaking very clearly, is a quasi-constitutional demand for Congress to take its role. So that it's accepting the existing constitutional framework, but that Congress has an active job here in terms of, has a role to fight against domination. That is an affirmative obligation, not just a negative obligation. So it's less about the role of the court, it's more about the constitutional support for the role of the Congress has been quite central. And then the third area that I have been involved in is very related, but related to surveillance and speech and workers' surveillance. And in that area, I think you see a kind of similar calling on, but only in distant echoes, the constitutional qualities. So I'm just trying to answer in like concrete terms. I don't know precisely what to make of this, but I gotta say, I think the anti-monopoly movement, long way to go, but has been pretty successful in less than 25 years, in terms of Tim Wu's really extraordinary role in the White House, Joe Biden saying that the Bork vision was a failed experiment. And this is extraordinary language from the president to say it's a failed experiment. And that hasn't been in constitutional language. So, there's a sort of latent power when the question is, what is stopping us from our progressive political agenda? Yeah, there's a lot of constitutional limits. This sort of part one, absolutely, the Senate. But there's also a kind of lack of ambition and role taking on the part of Congress and other state houses that is not constitutionally constrained.
Thank you, Zephyr. So I'm going to go to Professor Jed Purdy, who's a professor now at Duke, and teaches a range of topics, including environmental law, property law, and constitutional law. So Jed, on to you.
Thanks. Thanks so much, Olati, and everyone else. Excuse me. This has really been an extraordinary day already. I think I will take the chance to be the last to thank Evita and Caitlin, because they really are so wonderful to work with. In any event, the first this afternoon to thank them, and to thank Joey and Willie once more, specifically for writing this extraordinarily rich, deep book, and then doing the most generous thing and offering it to us as an occasion to talk about all sorts of things that are prompted by it. There's something quite selfless in that way, the way you've brought us together. So a few thoughts about where we've been today. We've been so many places and so well that I want to avoid repetition, yet try to build on what's been said throughout. The first is actually quite small, but a recurrent theme today has been, who are we to talk about these things anyway? And I thought about it. The philosopher Bernard Williams made this interesting distinction, I think, between two kinds of arguments. One that purports to tell people what they may not think, and the other which tries to suggest to people something they might not quite have thought yet, or might have thought but thought in a different way, or which might build on a thought they'd had but not quite articulated. I think we're probably in no position to tell fellow citizens, movement activists, and so forth what they may not think on pain of error. And there's a certain conceit about what constitutional lawyers do that suggests that's somehow like the paradigm of constitutional reasoning. But I think we're in a reasonable position as anyone else, flaws and all, and with certain maybe advantages, at least of leisure and time to examine history, to find interesting friends we may have lost touch with, to make the second kind of argument for what it may be worth, kind of in the form of a civic and political and intellectual proffer. So that's one way of thinking about what we've been doing. I think in all of our conversations today, we've been divided, and I think divided within ourselves for very deep reasons, actually, which Ash articulated nicely, between two senses in which we can engage political economy. The first is something we are trapped in as a domain of exploitation, domination, marginalization, and accrued historical injustice that patterns our lives and the lives of everyone around us and feeds into the formally articulated systems of power and authority in which we find ourselves. Of course, it does other things too that are more benign or appealing, but because that set of dimensions is most likely to be sort of ideologically excluded or shadowed in the American setting, and because we tend to be on some kind of left, we will emphasize the first set in talking of political economy. So that's one sense. A political economy is something in which we're caught. The other is political economy is something we make. That is, we also tend, by and large, I think, come here as people persuaded that ideologically, Americans recently and over time have been encouraged to underestimate how far the economy is a product of the action of the state, of political decisions, of legal engineering, and that what is made can be made differently. So we're sort of talking concurrently about a domain of constraint and slow violence, and a domain of empowerment and collective action. And we can't really keep them separate. It's more a kind of bifocal. It's precisely because they're so involved that we care about changing them, but it's also because they're so involved that the ways in which we're already living make it hard to jump over our own shadow and change them. The third, in talking about the direction of an egalitarian democratic political economy, we have been talking all day about social facts that don't exist yet, the facts of an egalitarian political economy, to be created by majorities that don't yet exist, or which are not presently able to articulate themselves because of anti-majoritarian features of our Constitution. Again and again, our discussants have returned to the thought, which I think is correct, that really the only agent, the only actor that can produce the social world toward which we're hoping to bend our efforts is an empowered majority. Aziz said, a public that can think of itself, a majority that can think of itself as a constitutional agent, and others in one way or another said similar things. So such an agent, I think, doesn't need the US Constitution per se, but what it does need, and this returns a bit to the theme of the two faces of political economy, what it does need is a way of articulating our divisions and inequities and mobilizing around them in ways that somehow hold on to or affirm or point to enough commonality of one kind or another, enough resources of, what shall we say, legitimacy or common trust or something like that, that the thematization of the divisions and the intensification of the divisions can be imagined to lead to not a permanent resolution, but a next treaty, a next way of living together that can be better and can also stick for a while, can also work. In the last decades, and also over the longer course of American history, the Constitution has stood as a sort of symbol of that latter commonality. I think some Aziz and Sam have very powerfully reminded us of the limits and the harms involved in that symbolism. I think, and nonetheless, we are, I think, we have been drawn to frame the conversation the way we have, I think partly because it carries that quality. When I hear constitutional political economy, one of the things that I hear is an effort to invoke simultaneously political economy as something we're trapped in, and political economy as something we make, and as something that we could make together, with constitutional standing partly for the possibility of acting together in politics. In brief, a last thought then. If we can say that a successful democratic politics requires something, let me call it, for lack of a better term, democratic trust. I don't mean anything very sentimental or very conceptually heavy by that, but something, what I'm calling togetherness, or the willingness to stand still for and live with the decision of a present majority of the people that you're caught in the country with. To rule or be ruled in turn is Aristotle's famous phrase for it. I think we should note the reasons for worry that we may be having this, that we may be able to have this conversation in part as a symptom of factors that also make it less likely in some ways that we're going to be able to move forward. That is, the very freeing up of constitutional and political imagination in this moment to articulate intensified calls for democratic empowerment and mobilization may also be in some ways linked to conditions that make it less likely that we'll be able to achieve stable majorities. This is conjecture, but one is simply the much more intensely felt confrontation with the anti-majoritarian, anti-democratic features of the Constitution. The Supreme Court's lock on constitutional interpretation, the Senate, the Electoral College, etc., which others have referred to, Article 5. The alienation of the center-left legal elite from the Constitution and the court in the last few years has been a part, I think, of the condition of receptivity to this sort of radical constitutional thinking, and I think quite properly. But we're also it highlights how much we're up against. It really does. How suited the Constitution is as now constituted to a certain kind of minority rule entrenchment that is substantively very bad for us. It may also be true that a part of the loosening up of constitutional imagination on the left is related to the fierce affective polarization in which we're involved. One of the major symptoms of features of this polarization is the feeling on either side of the political divide that it would be basically intolerable for the other side to have much power, to be in charge. Our partisans feel that, their partisans feel that. It raises the stakes. But it also makes the prospect of resolution harder. Then a sort of third thing, and then I'll stop. And I would like to be wrong about all of this. Like Zephyr, I have agreed with much that's been said today, including things that are mutually inconsistent and flatly contradictory, and that's been part of the power of the day. So this is just trying to give us something to think with that we haven't explicitly thought yet. I also think it's true, and this is more familiar ground, that there are a lot of ways that our political economy, as it's developed in the last 50, 60 years, has been just corrosive of our democratic capacity. Kate and others have written very powerfully about this. The fragmentation of the labor economy, the evisceration of the institutions of collective power among working people in the form of unions, the loss of the workplace as a sort of site of shared interest and a locus of organizing, the partial return of these kind of labor dynamics in the last few years has been inspiring, but it's still small compared to the sort of the heyday of the 20th century. So to the extent that one of the important questions about our economy is whether it presents us to one another as people who could engage in democratic action and rule together, and whether it accustoms a lot of us to think of ourselves as people who deserve that and are qualified for it. We have a lot of uphill work to do in that respect as well, because of the dimension of the political economy as something in which we're caught. Thanks for the chance to speak. This is really an amazing day.
Thank you, Jed, and thanks for putting on the table the question not just of reclaiming or deploying the Constitution in particular ways, but maybe amending it to rid it of its anti-democratic features, right? That's part of the discourse, and folks touched on that earlier today, as well as thinking about state constitutionalism as a resource because it has such a different democratic vision, of course, limited by the fact that then your change will only be at the state level and maybe won't diffuse for a while nationally. But I think you also posed a challenge around the question to which constitutional argumentation could be a source, a resource, I think, as you put it, for movements. And I wanted to ask both Alex and ReNika about that in different contexts. I mean, Alex, you've studied the labor movement, obviously in conversation a lot with our colleague, Kate Andreas, on some of these questions. And I know that you're not a lawyer, but you are fully aware of the ways in which the labor movement has used constitutional argumentation. And then at the same time, a lot of your opening was around the way in which big business sort of more strategically exploits the Constitution. So there's a sense in which we are engaging in a discourse that's so sincere and others are being far more tactical is a kind of story that emerges from that. I just wondered your thoughts on that. And then ReNika, as I see it right now, I mean, you were saying, yeah, we try to use constitutional arguments where we can. Where I see at least the racial justice movement, and if you think about the most powerful social movements in the last few years, maybe the movement for Black Lives, to some extent, it's abolition, Me Too. Not only do they not put the Constitution central to any of that, they don't put courts, they don't put statutes as they currently are for a range of reasons, right? They have a more transformative vision is what they would say. And in some sense, they emerge out of the failure of all of those methods of change, right? And so in that context, people don't look to history at all. The narrative is very much around creating something new, and that history will never be a resource for this more transformative vision. So it just made me think, given what Jed was saying, and the premise of this conference is, what kinds of resources does the Constitution really provide, and maybe saying a little bit about it in those two contexts, labor and racial justice.
Should I kick off?
Yeah.
Great. Sure, happy to speak to that. And I think it could be helpful to separate out the use of the Constitution, as we did this morning, as creating structures and opportunities, and then as a rhetorical tool. And I think on both counts, the case of labor, and in particular, advocacy by the right, broadly construed to include a broad set of coalitions that are opposed to more egalitarian economic and social outcomes through the labor movement, have been excellent at deploying both of those, although in different ways. And I think a key move in both cases has been thinking really strategically as policy as an opportunity to shift power and set the rules of institutions that have knock-on effects for policy and politics in the future. And I think that's something that on the left has been a lot harder for us to do, and I think comes through nicely in the book, thinking about policy as a technocratic tool rather than one that can imbue social movements with power and opportunity in the future. And you can think about using policy in that way, either to bolster majorities or the coalitions of the type that Jed was just describing, whether you're making it easier to organize by, for instance, subsidizing social movements, as Kate has written about in her work with Ben Sachs, making it easier for individuals to connect their experiences to government programs so that they can recognize the positive role that government can play in their lives, or creating new state apparatuses, whether they're federal agencies or social programs that can entrench particular norms and practices in society. All of these are powerful tools for bolstering power on one side. And just as easily, these tools can be used to demobilize too. And here's where I think the right has been particularly successful at deploying a variety of tools to demobilize labor, whether that is making it harder to organize, making it harder to collect dues, making it more challenging to strike, as we're seeing now as a new right that is under threat. All of these are power shifting reforms and take advantage of both the structure of the Constitution to the extent that there are these multiple venues that policy advocates can pursue. I think the right has been very strategic about using that multiplicity of venues to their advantage and figuring out where does it make sense, for instance, to bring court cases versus trying for referenda at the state level versus flipping states. And playing off those institutional venues against one another in a way that I think progressives have been slower to do. Rhetorically, I think there's been less use of the Constitution as a device on the right. When I look to anti-labor moves on the right, I see the use of the Constitution as a rhetorical device in legal arguments, but when I think about the arguments that have been deployed by the right to weaken labor in other settings, they've been very strategic and have varied. For business, it's about weakening a political opponent that supports progressive taxation and regulation. For social conservatives, it often involves channeling racial resentment and appeals against, say, public sector labor unions that represent ethnic and racial minorities. So I think it's been much more strategic and depends on that venue in which they're pursuing policy change.
Thank you. Right, and I think similarly
Oh,
for
ReNika, talk closer to the microphone because I don't think Zoom was picking you up before.
okay, is that better?
I think so. Everyone can hear?
Okay, just let me know.
Yeah.
So no, I was thinking of one of our cases where this is a school to prison pipeline case where we were challenging a statute. This is in South Carolina. And so there was a definite dialogue and exchange between the students, their families, and the communities that were organizing and our understanding of the situation there. And so in terms of when I think about the Black Lives Matter movement and the defining of principles that, again, did not look to the Constitution in terms of how it defined its key principles by which it was guided by. But then we as lawyers looking to those and thinking about how does our Constitution align with that, and how do we use that in the form of a court to advance objectives to stop the kinds of behaviors of the state that are really oppressing the communities that we work with. So in this case, we were challenging two statutes, one a disorderly conduct law, the other was called disturbing schools law. that was being used by police officers in the school to really deal with typical adolescent behavior. And we represented students who were Black and with disabilities in terms of how they were being either detained, how they were being charged or arrested because of their behavior in the school, and that being treated as a criminal matter as opposed to a violation of the school's code of conduct. And we were able to win on a challenge under the 14th Amendment, making vagueness arguments about how the laws were written and how they were then enforced in a discriminatory manner. And we were able to secure wins in both the district court and most recently last week in the Fourth Circuit. But at the same time, what the community was doing in turn was looking at those decisions and using it to organize in other places around the state. So we had the benefit of speaking with some parents who had heard about the decision and then thought about some of the practices in their district. And so it's not simply like a static statement of how movements, whether and how movements are using the Constitution as a document, as a source of law, but we as lawyers using it and being in conversation with different communities that we know are facing various, in our case, mostly focused on the state and or large quasi-state-like corporations. So we're thinking about how do we bring the Constitution to the principles that are being defined by movements and by communities as well. And so it doesn't feel as this is what it is, and that is what it is for now and forevermore, but it is really much more fluid, the conversation and how it works. And that is a function of how we are thinking about it as lawyers and how we understand that the movements are not necessarily fully looking to the Constitution as a document, not looking to the courts as the source of power because of the failures and limitations in access and responsiveness to the problems and the needs that they have.
So some of that tactical view of it is happening on both sides, but it also sounds like some of the constitutional notions are being used to organize people. Right. I wanted to get to some of the risks of making constitutional arguments or limitations that came up today. And even though it's following from some of what ReNika and Alex said, I think other people can comment on it too, which is this notion that there's limited time, there's limited resources, but I think it was more than that, that there was a sense in which constitutional argumentation is necessarily elite. You can think about who feels equipped to make these kinds of arguments, who's in the room. If I frame something around a particular right, like racial justice, I get a different audience. And if I frame it around constitution and political economy, the extent to which we frame or we contribute to constitutional veneration was one of the things that came up today in the conversation. So I wondered what you see as the risks. And Katherine, maybe kicking off with you, since you touched on some of that in the context of the gay rights movement, which I think you took to say that it necessarily, once you made those constitutional arguments, was going to be thin. But maybe you didn't mean that. Maybe you don't see that it's necessary. It's just about how one does this strategically.
Well, there's whether you bring a constitutional argument, a claim, and then how you frame that claim, I think is really what the marriage equality movement teaches us. And I've got some students in the room who we're going to do this on Tuesday. So if you have done the reading already, then you'll be ahead for that discussion. There are lots of ways to get to the right outcome, many paths. In almost any of the kinds of work where we're all struggling. And in my mind, the path taken in the marriage equality movement was the least best path of elevating an idea of the privatized family and the dignity of that marriage confers on couples that are deserving of that dignity, as opposed to an equality kind of argument that would have opened up and enabled a whole other set of constitutional claims and ways of being visible to the Constitution, and perhaps connections to the racial justice and reproductive justice movements than the dignity argument did. And that one of the primary problems with dignity is that it works largely through the specter of the constitutive other, the undignified other, who in the United States is almost always already an other of color. So it's the failed Black family that lurks in the background. I think of Obergefell, against which the successful, dignified white same-sex couple is seen as deserving of the blessings of the Constitution. So I think the question isn't only do we go to the courts with a constitutional claim for the world we want to build, but and say that the Constitution should see us, but we have to be very, I think, quite careful about how we frame those claims and who else has stakes in not only when we lose, but also when we win. And in that sense, I found Obergefell to be a disaster.
What do you think about this question about some of the risks of this work? And it's the ambivalence that we've been going back and forth with all day.
Yeah, I mean, as you were speaking, I was thinking of, what is it, June 2013? Richard, I'm going to ask you, when was Shelby County? June? Okay.
The first time I've been called on in 40 years.
Well,
And now
I'm
you see
encouraging
it's
you did
not
well,
fun,
right? But the same week that Windsor came down and Shelby County came down, is sort of this moment where it was almost like a dare. Like, how was the progressive left going to respond to this moment? It felt like a dare in terms of what is the court? What is the Constitution and what is the court? And at that moment, the response was the court is recognizing and seeing our dignity and our rights, and there's a bad decision. You know, the sort of collective response to Shelby County was bad decision, good overall framework of what the Constitution is and what the court is. And I think now we're in a different moment. The risks we saw over the last 20 years, we've seen a lot of those risks in terms of what the court has been able to do while maintaining its own, the court's dignity, the court's authority, and constitutional supremacy tied to that. I mean, I think I alluded to the risk, one risk earlier, which, what was the theological statement by Sam? Nobody is going to save us when we all die anyway. What was his name?
No one will save us from loss forever.
Thank you. But there has been some complacency about the actual legislative powers that we have to actively create an economy, to actively subsidize home ownership, to actively break up big companies, to actively empower labor, to actively support other institutions. That the idea that this is a protector of those, that's a real danger. Luckily, I don't think that's an existential danger. Mm-hmm. Like, you can do both of those at the same time, right? So the more existential danger is, I think, can you have a half-sacred constitution? You know, like, not the Senate part, but these parts. And if so, how do you sort of publicly, simply talk about this half-sacred institution?
Yeah, so Jed, I'm going to give you a chance to answer and start thinking of your questions, because I'm going to open it up to questions.
I think the easy answer, there may be too easy, is that what stands for the possibility of the self-rule of equals is sacred, and what stands in the way is not. It's not because it's the Constitution, but to the extent that it can embody that, it is something of transcendent value that we can make. And to the extent that it doesn't, it is an inherited problem. There's still a psychological problem, whether it can be both, but that's just our problem. We have to work on that.
Yeah, I mean, that's a lot to think about, right? I think I'm with everyone else when you say you go back and forth on these questions. I've always thought of myself as sort of the person who's more skeptical of constitutional arguments, since, as I mentioned at the outset, there was no real space for them when I was practicing law, other than the arguments about Congress's power to enforce the 14th Amendment. But I see just such a price and a cost of not investing in them at this point. I mean, just to use the example of the affirmative action cases, some people think, oh, it's just about elite institutions and what happens in those cases, but actually it's about environmental justice remedies, it's about workplaces, it's about K through 12 education, it's really about the core meaning of the 14th Amendment and your ability to redress inequality. And so I think that it really comes at a cost. That's my take on it, to not invest in those arguments. But I do worry about the constitutional veneration part and whether we contribute to that. Okay, let's get some questions in. And I know that so.
Wait.
Yes.
Okay.
And then next to you after that.
I do have a question for Director ReNika Moore and Professor Franke specifically. I understand we've talked about opening constitutional discourse to a wider audience, but I do want to turn back to judiciary for a little bit, because many cases for civil liberties and civil protections were argued with a specific legal strategy to thread the needle to get enough votes from justices. And by that, we see, how the means and the results are separated in a way. And we see how the means have been sort of tackled recently to undo the civil protection. So I wonder, with the emissions policy, race-conscious emissions policy, and reproductive rights. So I wonder, is there a new legal strategy within the constitutional realm that the ACLU is employing, or that the progressive side is employing to, create a new realm of more sustainable reasoning justification for the civil protection? Or are we just working with the realms of statutory rules and outside of the Constitution?
So I want to make sure I understand your question, and I think you referred to me as Dr. Moore. Doctor. That's right.
You are to us.
Jurist, so I just want to make sure I understand your question. Are you saying, how are we thinking about how we can make the constitutional arguments in a way that allows for like a more expansive view of rights, even if we lose these cases, or are you saying something different?
I was just wondering, because how in the past the means to justify enough votes at the highest court, for instance, is now being targeted to take down the result of reproductive rights, for instance, and now race-conscious affirmative action. So I'm wondering, are there new legal strategies that ACLU is employing within the constitutional realm to create a more sustainable and more long-lasting, for instance, extension of the justification for the extension of rights that were taken away?
Right. So, I mean, I think it's the fact of the matter is, and I often, I think there's sometimes lawyers, particularly around the Supreme Court and the Constitution, predict with a level of confidence that is not always borne out in what actually happens. And so we are often dealing with the circumstances as we see them. I clerked for Judge Robert Carter, who was one of the architects of Brown v. Board, and and he was the first to say we understood that we had to attack segregation in schools, and that we thought that would lead to the fall of inequality in education, and that we underestimated the ability of white supremacy to reorganize itself even once we eliminated de jure segregation. And so I think the idea is that as we look to the ways in which the court has changed, and we moved from in thinking about affirmative action as being reparative or addressing kind of existing discrimination, and I say we, I mean the civil rights movement writ large, not just the ACLU. As Olatunde mentioned, we started our careers early on at the Legal Defense Fund, but that we are thinking about what's also changing in terms of the values of the larger society, and what's happening in the sense of a move to rationales around diversity and the value of diversity. And even as we are arguing making arguments to the court about the value of diversity and what the Equal Protection Clause means and what it is supposed to guarantee as an affirmative step toward equality and equity. We still are seeing attacks from the right, not just around race-conscious actions, but around race-neutral actions that consider the impacts of race. And so I think the fight on the other side is very tactical, and so the justifications are not always in good faith, and so we have to move to address those as well. I think for us, we are thinking about like how do we think about and conceive of the arguments, and how do we understand what equality and equity look like in the society that we have today, which is taking into account more than just race and black and white as a binary. We have a much more diverse racial constituency than we did, I think, at the time of Brown, and even, you know, at the time of some of the first affirmative action cases. So we absolutely are thinking in more nuanced terms about what equity looks like and how we articulate it in the context of the Equal Protection Clause and the 14th Amendment. And then we're looking to state constitutions, which we haven't talked about as much yet, to think about, because under a number of state constitutions, there are also guarantees around education and sometimes housing, or like other rights that are not articulated in the US Constitution. Thank you.
Hi, I just wanted to go back to some of the things that you were discussing at the start of the panel. So particularly some of the questions like who makes the constitutional arguments, who gets to define what the Constitution means, and also I wanted to talk or bring in the keyword empowered majority, and I was just wondering your thoughts on constitutional accessibility and how this may affect how obviously like the constitutional debates that we have, like this forum and this panel, happen very often in like very privileged spaces that not a lot of people have access to. And I'm wondering if these critical debates taking place in spaces that are very inaccessible to people has an effect on why the ideas of our constitutions may remain really static in like common American life.
Anyone want to take that on?
Can I just say we're putting together a curriculum, a high school and middle school curriculum around the ERA that would be a history of the Constitution, a history of political movements, certainly a history of race and sex equality. So I totally agree with you. We should take this stuff outside of this room. It's good we're having it here, but so much of what we do, let's just say that these walls should be porous. So if you want to work with us on these curricula, we'd love to help.
I think there's a few different questions around the elitism. One is providing the like basic skill sets of our professional tradition to a broad majority. And the other, which is I think the challenge in the argument in Joey Willie's book, is say if somebody stands up and says healthcare is a human right, that's a constitutional right, but doesn't have a clause to attach it to, that is a legitimate argument. And I use that as an example because that's an area where there's actually a pretty broad public sense of rightness. It's a rights language, it's constitutional language. Hard pressed for anybody in this profession to say where on earth you'd even begin to find that as a technical high stakes posen matter. So like, just imagine yourself with somebody, somebody saying healthcare is a constitutional right, and then you say, what, that is a valid argument? Like I want to democratize it too, but I also want to think about what that means in a way that is honest.
Yeah, and I know that this is somewhat controversial. There's a split of opinion whether to go this route, but people who claim themselves to be abolition constitutionalists, right, would say that one of the reasons they talk about the ways in which the 13th and 14th and 15th Amendment were shaped by abolitionists is to reclaim the notion that it's not just elites who created those constitutional provisions. You had enslaved people who were making freedom petitions. You had people who were non-lawyers, and you certainly had the Frederick Douglasses of the world. But you didn't just have the official congressional drafters. And so part of that move is to remind people of the 13th, 14th, and 15th Amendments, but it's also to remind people that ordinary people may claim and shape constitutional meaning too. And so I think that can be useful to remember. And a lot of people are trying to create sort of popular versions of this, like truly popular books and things like that, that will talk about that. And you may see that in the months to come. Richard Burkholz.
Thanks. I'd like to tell my students that I do cold calls so that afterwards they feel comfortable volunteering, so I thought I would model that. This question might have been better for the prior panel, but since a number of people already raised states or experts on states, let me throw this out. State constitutions lack most of the most non-democratic features of the federal constitution. There's no electoral college. There's no longer a territory-based Senate. There is no lifetime judiciary. In most states they're elected, and in half the states we have direct democracy. And as ReNika just mentioned, we have lots of substantive rights. Every state has a right to education. Many, like New York, had housing. New York just added environmental rights. So my question is really, are we closer to social democracy, or did they make a difference? Are we seeing a more vibrant democracy at the state level? Are we seeing a little bit or a lot or not at all, or is the problem, or is it simply that whatever we do at the state level, it's not, the federal constitution looms so large, so that the state room for maneuver is limited. But this is part of denaturalizing, to use the earlier buzz, is to kind of get a sense of the constitution is a variable for these things. And what do you think? I mean, are the states more open? Are we more likely to achieve these actions at the state level where we have a much less constrained constitution all across the board? Or is it simply the states they matter at the margin, they don't matter enough?
I have two really quick thoughts about that. One is that in most cases, the small economic footprint of the states, California being an obvious important exception, makes a big difference if we're talking about political economy innovation, because the states are more like small countries that are basically takers in terms of policy incentives, where the US can actually do something to shape the global regime. I also think, I should be asking you this, but my sense, having spent most of the last 20 years in North Carolina, is that the nationalization of state politics is so intense that the themes that get activated through more majoritarian, or at least initially more majoritarian systems, end up just being sort of refracted versions of national campaign points in the present moment.
In addition to nationalization, I'd point out a couple other structural features that I think are particular hindrances to those seeking egalitarian outcomes. But let me preface at the top that that's not to say that we shouldn't be contesting that terrain or trying to work through the states, because if not, I think we'll be in an even worse position than we would be otherwise. But as I was referring to at the top, what makes the US so distinctive as a federal country, as you well know, is the lack of revenue sharing and other fiscal arrangements to help support states in carrying out redistribution and social spending. So to the extent that the rights that people are able to introduce, the substantive rights, have large fiscal obligations, it really makes it difficult in the American context, given that combined with the opportunity for capital flight, or at least the threat of capital flight. Other structural features of the states that I'd point out are the low capacity of the state legislatures, a personal hobby horse of mine that leaves the state legislatures open to more interest group activity and capture, to the extent that they're relying on private sector groups to be supporting them through model legislation and research. And then the last piece is, which I also know that you know well, is preemption, that in many of the crucial spaces where I think those seeking more egalitarian outcomes like labor would like to take action, that space is increasingly being taken up by curbs at the national level that prevent that kind of experimentation. But with all of that in mind, it's not to say we shouldn't be trying to work through the states, particularly in ways that ladder up to national change, thinking strategically about changes at the state level that can build power at the national level, and vice versa for that matter, taking advantage of the control of government that we have right now.
And I'll just add, in terms of the state constitutional advocacy that we've been engaged in, it has principally been around education, which, because of the way in which it's organized and because state constitutions often have adequacy of education provisions that it makes it well suited. And we've had mixed success with those efforts. But I think for a lot of systems that moving through the state constitutional regimes leads to like inadequate or patchy solutions as well. We also do a fair amount of work around algorithmic bias, and so much of that funding and the provision of that is coming from the federal government, and where we found that states have created stronger protections because of the way that the internet works and the way that technology works, that it doesn't necessarily filter down because you have so many holes in that net. So the benefits of state constitutions, certainly we see are worth pursuing in certain spaces, but it is a very incomplete model in our system. Alex has much more eloquent explain. Yeah, so I think we could take one more question. Yeah, Madiba.
Hey there, folks. So I wanted to pull together a couple threads we had been going over, especially in the last panel, but really all morning. We've been talking about revering versus redeeming, or sometimes even rebuking the Constitution, and how people feel very strongly about it, but don't feel like it's actually theirs, and that there's this very like elite conception of who gets to interpret it. And how do we actually put that simply? And so I sort of wanted to toss out there, because to me it actually did seem kind of simple. I think that like all of us who may have been on the receiving end of a firm reprimand or gentle reprimand at any point from a parent knows the virtue of tough love. So we can sort of like get that idea out there instead of like not having to pick between revering or rebuking, and just saying like, hey, the Constitution has a lot of valuable points in it, but it hasn't been working for all of us. And when we talk about we the people, we means me too. And if we think that's something that could work.
So I can say, speaking for our organization, in fact, one of our, as we reconceived our mission statement, or trying to come up with something pithy, we opened with we the people, and just recognizing just the breadth of our work, trying to account for the racial justice work, the LGBTQ work, the anti-trans work. So we absolutely see that as like a mission and an obligation that we have to bring more people to understand that the Constitution is ours, and we get to define the terms of it. So I say yes, but others want to weigh in?
I love the way of putting it. I think for me, the ultimate question is, are we talking about an appeal of tough love to the document as interpreted by judges who are finally going to tell us whether it means me too or you too or not? Or are we ultimately talking about appealing to the other people who are living under it in the current generation to decide what we're doing together?
If there's anything, I guess one of the things that I take from critical race theory in its answer to critical legal studies and the degree to which CLS sort of fell in love with their own critique and abandoned the Constitution and liberal legalism is a kind of pragmatism. We'll use it when it's useful, and we'll turn away from it when it's not. But it's not. It's something we cannot not use if our movements need it. So the ultimate question of whether we should revere it or not, that's the wrong target of reverence, I guess.
I go back and forth on this, sort of this question throughout the day and just throughout my own and our own collective work. But I am inclined to think that it is difficult to have a political community that you could call a political community that doesn't have some shared symbolic system that is in fact revered. And that reverence need not be absolute. And so I think it is not just a negative question. It is, what are the active symbolic systems that we think enable productive, I don't want to be a utopian, enable productive and unproductive, but possible actual engagement that can lead to action. And where can we call on those? And so I don't think it is, I don't think we can only be pragmatists about it, I guess. Or I don't even know what pragmatist means, but I don't think we can only think of it in moment-to-moment ways. This is about a set of collective meaning making. And I don't think the economic left should give up on collective meaning making.
With that, we'll end our panel and thank our panelists.
It's just great meeting together. He's like, I'm going to see you guys. These two are the only one in the room for players.
So are you in DC?
Yes, I'm in DC. Yeah, just up here for the day. But yeah, it was fun to participate. And yeah, I mean, great to hear the work that you guys are doing. I'm especially interested on the algorithmic discrimination.
It's so funny. I was like, we were talking about R&D today. So do you know Sarah?
Yes, absolutely. Yes, but she left.
Exactly.
Yes,
so she left, and
Alan Misloff is the new person that OSCP took over.
We're committed to ending on time, so we're going to get right to the last presentation.
Yeah.
I'm just saying.
Yeah, it's better on this. Do you want me to? Okay. Okay, we're going to get started. So I have the pleasure of introducing, we're going to get started with the last panel or last event. I have the pleasure of introducing Ira Katz-Nelson, who is a remarkable political scientist and also the co-director of the new Center for Political Economy at Columbia World Projects. And I will turn over to Ira.
Great. Mask is coming off. It's such a treat to be here. First of all, let me just, no one has yet held up this book today. And it's heavy, but it's light in the sense that it's incredibly readable. When this copy arrived that you sent me, I guess in June, I opened it up and I was late on a deadline, and I thought, oh my God, how am I gonna? And then I started to read it, and I literally couldn't put it down. It's a provocation. It's audacious. It's historically informed. It's analytical, and so on. As I was saying to your co-author, to colleague Fishkin, it reads to me as, in the best sense, as an essay and a brief. That is, it's an essay, it's an argument that galvanizes history and its complexity, but to make a fundamental set of points that are meant to inspire us to think in fresh ways, both about the past and the present, but especially about the future. So I think that's no small achievement. And we're here precisely because of that achievement. Earlier in the day, the phrase, what was that wonderful phrase that was about, what was it? Let me not remember, but something about the landscape of authority. And a law school is a landscape of authority in which as Alex was saying about his own place, I'm a trespasser. But let me trespass in the following way. I want to share in sort of 10, 15 minutes what the agenda I've taken away as a non-lawyer from the book and from this really rich conference. And it connects to the new Center for Political Economy that Kate is co-directing, that I'm co-directing, Katherine Pistor of the law school, and Suresh Naidu of economics, because we have foregrounded this new infant that has just been born we foregrounded three concepts: power, equality, and uncertainty. And all three resonate through this exceptional book. Now, what about the agenda? I'd like to talk about three things. A set of issues marked by inherent constitutional ambiguity and tension. The three principles that are in the book and that you summarized, Willie, at the beginning of the day in the book, and then say something about institutions and the ways in which institutions affect and shape probabilities. Now, the subject of all of these is representative, constitutional, liberal democracy. All those words matter. And just as a way of shorthand, let me just say that I take for granted that no one in this room would want to live in a regime absent the rule of law, absent government by consent, absent individual and collective rights, absent political representation, or absent some separation of powers. The world's full of regimes that lack those, and they're pretty ugly. So the question for me is, under what conditions can normative goods like equality be combined with the core features of a normatively desirable liberal constitutional representative democracy? And that's how I read this book, as a challenge to see whether or not this kind of charged domain can be made, has been made practical, and can be made even better. Now, let me start with, there are three sets of issues of which the books is one, which seem to me are inherently, inescapably charged with tension and ambiguity within such constitutional regimes. They are, first, the question of membership. We live not in one world, we live in a world of nation states. They have boundaries, they have barriers. And the barriers include barriers to entry, both external, immigration, internal, hierarchies of race, for example, or disenfranchisement. The liberal constitutional tradition has lived on all sides of those questions of membership, because there always is the issue, who gets to enjoy liberal rights, liberal representation, the rule of law, et cetera, et cetera. You have to be a member, you have to belong. And the rules of belonging have been contested from the very beginning of this republic. The 1790 Act of Naturalization, the first, specifies white people, literally in the law. And we continue to have on our southern border and elsewhere enormous debates about who enters and under what conditions. And internally, of course, questions of hierarchy, color, et cetera. Second set of issues for which liberal democracy has tensions, but no inherent answers, is the question of national security. If you read Federalist 23, or it reads like John Locke on prerogative, Hamilton says circumstances of security outside the law. Don't be constrained by constitutionalism and law. This in a document selling the Constitution to the American people. And that's a longer story. We don't have time for that today. But the question, no state, not ours, not Ukraine, no state can fail the tests of security, but achieving tests of security puts inherent strain on constitutional and liberal democracy, inescapable strain. Third and last is the subject of today, political economy, questions of property, wealth, distribution, the material content of citizenship and rights and consent and all those liberal rights. And that's what we're talking about. But I do not think the answers lie in the written words of the Constitution, except to say that they inherently inhabit our Constitution all of these tensions. If you read the texts on declaring war or commander-in-chief powers and so on, they internalize the tension. Questions of race. There are slave provisions, obviously slavery provisions in the Constitution, but there's also, Frederick Douglass said it was a liberating document. Two things can be true at the same time. And the same is true about property and distribution and material reality. It's not a fixed zone constitutionally, it's a combative zone constitutionally. And that's what the book, as I read it, is all about. Then let me go quickly to the three principles in the book. Against and correct me guys if I got it wrong, against the concentration of power, the dispersal of economic power and means, and the need to include all citizens at least, within the ken of the constitutional polity on equal grounds, right? Okay. Well, you make more than gestures, you show from time to time just how hard it is to maintain the three in equilibrium. In truth, I think they've never been in equilibrium in the American experience. And if you take even some of your most positive examples of movements, egalitarian constitutional movements, Jacksonian democracy, late 19th century populism, they certainly were charged with racism. And underneath those principles lies, it seems to me, the profound dilemmas of popular sovereignty. Think of Lincoln rejecting popular sovereignty as the means to resolve westward expansion questions in Kansas and Nebraska. Under what conditions does democracy work within a constitutional frame to make it possible to link these three very desirable normative principles? But what are the barriers? What are the limits? And there I even wanted to know more, because it seems to me that we are faced today, I don't know, how many 70-something million people just voted for 2-3 years ago for a candidate for office for president of the United States who certainly didn't live by these three principles. So we can take none of it for granted. And the question is, under what conditions? And that takes me to institutions, because institutions, above all, are linkages between structure and agency. And institutions affect probabilities. The reason you focus on Constitution, because you want to shape our discourse about the Constitution so as to affect probabilities of decent outcomes. But that raises the institutional question about decisions and probabilities, raise really hard questions. So democracy, we want to combine democracy and liberalism, let's just say, or democracy and constitutionalism. Democracy is about agonism, it's about conflict, it's about discourse of debate about the appropriate relationships between state and society, state and economy, economy and civil society. It's a kind of a three-dimensional game. But the liberalism part of the constitutionalism is about constraint on democracy. And I think none of us should think that's entirely a bad thing. Why? Because there are two kinds of constraints built in. One is a constraint on predatory rulers. We talked earlier, Sam, who couldn't stay, I know he had another appointment. My dear friend said in his remarks, well, you know, the courts don't protect us. Well, they did protect us. Even the Trump lawyers protected us in 2020 against the depredation of the claim that the election was a fraud. We cannot do without checks on predation by rulers. But reciprocally, we also need checks on what the founders thought of as mob, demagogically led rule. And these are not easy questions, but democracy is not a pure good on its own. It has to be inserted within an institutional framework that canalizes it in ways which make two things possible: peaceful leadership change, which most countries don't have, and peaceful oscillation in the policy domain, so that if you win, the losers don't think they've lost permanently, and the losers, and we've been losers a lot, those of us left of center, don't think we're permanently losers. And constitutional democracy makes possible that form of oscillation and transition. Finally, there's one of the subjects within the institutional domain that we heard a lot about today concerns the balance among the Congress, or legislatures more generally, the executive, the president, and the courts. And here, it seems to me, at the end of the day, it's Locke who says the supreme authority is ultimately the legislature, but only under certain conditions. And his conditions included that the law treat all equally. So it's a kind of an egalitarian constitutionalism in Locke's trumpeting of Congress. And I too think that in a hierarchy, the site of representation has to come ahead of the courts and the president. We could talk for hours about that. But what is always true, is my last substantive thought, in any given policy domain of political economy, let's say, is that all three branches are in the game. There's a wonderful book, I'm not sure you cited it, by Richard Bensel on late 19th century industrialization in America, in which he shows that the capitalist industrial modernization in the age of the robber barons was fashioned by the executive with respect to gold standard, by the legislature with respect to trade and protection, and by the courts with respect to overturning what they thought were any impediments to the free activity of markets. But it was a constellation of institutions and decision. And we could argue, as I would, about hierarchy of who should be most important, but let's never separate out the judiciary, the legislature, the executive, but always believing in at least some degree of separation of powers, because absent of that, you just get executive dictatorship. Finally, truly finally, it seems to me that this is a book, some of you know I love the expression of John Rawls in his book, Law of Peoples, realistic utopianism. This is a realistically utopian book. It's saying we actually have the means, and the history, and the possibility to achieve something better than what we have. And it's a glorious book for that reason. But there are two other sensibilities that we always need, and I think you would agree. One, notwithstanding what my colleague, friend, Professor Franke just said, we also need to be pragmatic in mobilizing constituencies, in writing legislation, in making sure that we get the details right. But finally, we also need to be guardians against things getting worse. There's no guarantee, none whatsoever, that even the current highly inadequate status quo will not deteriorate under various foreseeable conditions. And it's for that reason that I think we need all three of these sensibilities simultaneously: guardianship, pragmatism, and realistic utopianism. Thank you very much.
Thank you, Ira. So Jed said he was going to be the last to thank Caitlin, but I will not let that happen because I probably benefited most from her work, from everyone. And also just wanted to thank everyone, the Columbia staff and students who helped make everything work today. Also very grateful to all the speakers who took time out of their busy schedules to be with us, and especially to Willie and Joey, who were the impetus for this event. And I am committed to ending on time, if for no other reason than I have to attend a parent-teacher conference. So I am running out of here as soon as I'm done speaking. But I wanted to start by just offering, in closing, a few reflections. I've had a number of people ask, including I think maybe even a colleague in this room, like, what is this whole political economy or constitutional political economy? What is meant by that anyway? And I think when I reflect on the day today, I think we're talking about it in three different ways. One is we've been talking about when and how to make claims about political economy in a constitutional register, so as Ash said earlier. And by that we mean not just in courts, although maybe sometimes in courts, but also in legislatures, in agencies, in states, in social movements. And we've talked about how sometimes it's useful, sometimes it's not. Sometimes it might be pernicious, and sometimes it might be really helpful and hopeful and an ability to imagine a different world. We also have talked about what kind of political economy the current Constitution constructs, and have spent some time unpacking how constitutional structure, how parts of the Constitution like Article 5 or the Electoral College, or in response to Richard's question earlier, not only preemption, but the Dormant Commerce Clause, construct a certain political economy and constrain the ability to change the political economy. How does the current Constitution shore up a political economy that is particularly anti-egalitarian and anti-democratic? And then third, and we've sort of danced around this a little bit, but I think kind of the question that might have brought many of the students to the conference is, what kind of political economy should our Constitution construct? And how can we construct a more democratic, egalitarian Constitution? What does that look like? How do we create a different political economy that changes how we constitute ourselves as a nation? And I think someone suggested earlier that maybe that's not really our goal as constitutional law professors, but I want to suggest that it really is all of our goal in the room, as certainly for those of us who are lawyers, but also for all of us as citizens, as residents, and as human beings, that we really have an urgent task in front of us, which is to think about what does a more egalitarian and democratic constitutional political economy look like, and how do we get from here to there? And that it is our job, it's all of our jobs, and as Ira was just alluding to, it's maybe an urgent job given the current state of our politics. So to some extent, maybe the picture is pretty depressing, right? There are some significant obstacles in the way of any real change, including the Senate and malapportionment, Electoral College, a court that's committed to a very anti-egalitarian, anti-democratic constitutional vision. That was very much on display this past week in oral arguments. But I wanted to close with leaving you with some optimism and reflecting a bit on the prior panel. So Katherine mentioned the successes of the gay rights movement, notwithstanding their limitations, but it is really stunning. I mean, in my time since I went to law school, it's been an utter transformation in constitutional law. And the flip of that is true when you think about the gun rights movement. So when I went to law school, there was no individual right to bear arms. Now there is, right? We have seen an extraordinary amount of constitutional change in our own lifetimes. And that came about because of political movements and social movements. Zephyr referred to the anti-monopoly movement. In that sense, I think the history that Joey and Willie tell is important, and that we heard about in the first panel as well, is important not only for finding friends, but for reminding us just how much change can occur. And it's not a one-way street, right? Things change and then they change again, maybe not for the best. But I think that when we look back at US history and history more broadly, we see the ability of all of us to affect change. And that is, I think, our job as members of this political community. So I guess I would say we've had, there have been a lot of really, I think, fascinating discussions, some of them somewhat abstract, about how to think about whether we should be constitutionalizing political argument. What does it mean to do that? How do we avoid having that become too much, too judicialized in a world in which the Constitution is very much, or in a country in which the Constitution is very much associated with the judiciary. But those are all questions to be tackled with, but I would say the mission shouldn't change, which is that we do have, I think, an urgent need to construct a more democratic and egalitarian political community. And I hope many of us in the room kind of join in that project. So thank you.